Hi, my name is Kyle Ingram, and I'm an attorney in Washington, D.C., and I represent federal employees in discrimination and related cases. I am today going to walk you through a formal complaint writing process. I'm going to walk you through a factual scenario, and we're going to break that factual scenario down so that we can include it in the formal complaint. I'm going to give you a look at the VA's formal complaint. I'm just using that as an example because I think it shows sometimes how difficult a formal complaint drafting process can be, and unnecessarily so, and how one can deal with that. And then finally, I'm going to show you a letter. I'm not going to write the whole letter, but I'm going to show you how I would structure a letter to attach to the formal complaint as a way of dealing with the unnecessary complexities of the VA's form. This is a factual scenario that I came up with for a Dr. Longfellow, just made up name. None of this is anything like any of the clients or anybody I've talked to before. I'm just pulling this out of thin air. So what I'm doing is I'm showing you here this is essentially a very short version of a story that somebody could give that I would take and then put into a formal complaint. So let me get started here and let me show you what I pull out of this. So I'm going to use a highlighter here. Okay, my name is Edward Longfellow. I was born and grew up in Fiji. So he's from Fiji. I am a physician with the U.S. Department of Veterans Affairs at the Crab Island VA in Virginia. Okay, VA, worked in the emergency department with Dr. Mark Menschenlein. While I was there, Dr. Menschenlein told me that he didn't like working with Fijians. Okay, he told me that he had been to Fiji and he was cheated out of money by some people there. He told me Fijians should not get to come to the United States even if they want to work because they will just cheat people. He repeatedly asked me while working together what I was cheating him out of. Okay. I first started working with Dr. Menschenlein in September 2019. He has continued to make comments from day one. Continued to make comments. That's actually very important. Most recently, he made comments about Fijians on March 31st, 2021. So I'm recording this on May 23rd. So this would be very recently. In 2020, I informed my supervisor, Dr. Angela Davis, of what Dr. Menschenlein was saying. She told me to ignore it and to keep my head down. At the end of this year, I received a meets expectations performance review. My mid-year rating, before I informed Angela Davis of my issues with Dr. Menschenlein, was outstanding. So mid-year rating, sometimes people get 2 ratings per year, sometimes 3, but almost all employees get some kind of mid-year review, and a major change in that is going to attract a lot of attention. It certainly does for me. Before I informed Angela Davis of my issues with Dr. Menschenlein, it was outstanding, and I was not doing anything different. So no change. I think that's very important. I was not doing anything different. No change in the performance, right? No change in the actual underlying performance that's being rated. So there's a question, why is there a change in the rating of that performance? Okay, I received my performance review on March 31st, 2021, and I did not receive a bonus like I normally did. Okay, many of my coworkers received a bonus. Okay, so let me point out here a couple of things. Number one, the dates. This is March 31st, 2021, March 31st, 2021. Let me rewrite that a little bit. There we go. Okay, those are really easy those stand out to me as an attorney because the dates are what determine whether somebody has met their 45-day deadline. So every employee has, every federal employee has 45 days from the matter alleged to be discriminatory to bring it to the attention of an EEO counselor. There are a ton of rules behind this, and it's far too complex for me to go into right now. But when you're doing your formal complaint, you want to be aware of when the event most recently occurred, particularly in a situation like this where it's a continuous action, because that's going to inform then some parts of these forms that you fill out where you say, this is when this happened, this is when that happened, right? In this case, Dr. Longfellow is saying that both of these events happened most recently on March 31st, 2021. He made contact, and the last bit here is I made contact with ORM on March 31st, 2021. Okay, so same day that both of these things happened. So that's great for him because that's easily going to fit within the 45-day timeline. If you have a question about whether your events fit into a 45-day timeline, this can be really complicated. And certainly what I've said doesn't cover all of the nuances of it. Talk to an attorney about it. All right. So I'm going to go back up to the top. And from what I see here, there is a clear hostility towards Fijians. That doesn't seem to be, it's pretty obvious here. But what may be hidden behind here is not just Fijians, but a racial discrimination. Asian Pacific Islanders, something that's come up in the news a lot lately as of 2021, but certainly there's no reason for Dr. Longfellow to limit himself in terms of what he's alleging here. So he could easily allege discrimination based on national origin. I apologize in advance for my handwriting, and race. Okay? That's just this top part. Now, to me, this sounds like a hostile work environment. Hostile work environment is where you have things that are being stated that are hostile towards a person's national origin, race, religion, color, disability, age, and even their former or prior EEO activity. Okay, it could be any one of the bases that are covered under Title VII. I left out sex, pregnancy, and including now sexual orientation. That's clear from the law. That's been true for a number of years, but it is obviously been. There's a recent Supreme Court case where the Supreme Court said yes, sexual orientation, when you're treating somebody differently because of the way they are oriented in whom they're attracted to, that's discrimination based on somebody's sex. So that's important to know because some people think that there is no federal law protecting people from sexual orientation discrimination. If it's based on, I don't know what would be sexual orientation discrimination that would not be because of sex. And at this point, that's the law. Okay. So going back into, that's beyond the point of this, there's no sexual orientation issue in this particular fact pattern. So the problem that I'm seeing here for Dr. Longfellow is that Dr. Mentionlied is saying these things. These are nasty, hurtful things about his national origin and potentially also about his race. But he's not taking any action based on them. So he's not terminating Dr. Longfellow. He's not subjecting Dr. Longfellow to some other kind of personnel action, such as a demotion, or he's not taking Dr. Longfellow and taking duties away from him. So the only thing that this really fits under is a hostile work environment. It's a type of harassment. Harassment and hostile work environment are really the same thing. We just use them in different contexts, but most people would use them interchangeably. Legally, exactly the same thing, same standards. This is a hostile work environment, potentially. And it's a hostile work environment based on national origin and race. So I'm going to put down HWE for hostile work environment. Okay, we'll come back to this in a bit. Okay, that's not the end of it, though. Okay, he also reported this to Dr. Angela Davis. Okay, this is actually quite important. When you have a hostile work environment, the agency has to know about it. If the agency isn't informed of a hostile work environment, they can't do anything about it. Okay, if it's a supervisor, this gets into a lot of detail. If there's a supervisor who's harassing somebody, the agency is liable, but they can get out of it. If it's a coworker, which in this case it doesn't look like, and there's no reason to believe that Dr. Longfellow is anything more than a coworker of Dr. Mentionlied. And in fact, here we've got Dr. Angela Davis as the supervisor. So we've got good reason to believe here that they're coworkers. So Dr. Longfellow and Dr. Mentionlied, they're on the same level. So in order to prove a discriminatory hostile work environment here, there needs to be evidence that the agency knew about the fact that this was going on and did nothing about it. And that's exactly what is here. And I would submit, if this were to go on, I would definitely say that is good evidence that the agency failed to take action, failed to correct the behavior of Dr. Menschenleid. In 2020, I informed my supervisor, Dr. Angela Davis, of what Dr. Menschenleid was saying. So he told Angela Davis about this. Now, there might be an open question about whether whether he provided enough information to put her on notice that it was a hostile work environment based on Dr. Longfellow being Fijian. It's beyond the fact pattern that we have here. We just know that he talked to her about it. He talked to Dr. Davis about it. And that she responded to him by saying, just ignore it. Just ignore it. Keep your head down. That's unfortunately very common for federal employers. A lot of supervisors take that kind of attitude of, boys will be boys sort of thing. It's not okay. That subjects the agency to liability. And frankly, if I heard a supervisor doing that, and if I were that person's supervisor, I would reprimand that person. I don't think it's okay for Dr. Davis to say this, and certainly it opens up the door to liability. At the end of this year, I received a meets expectations. Okay, so this is, again, Dr. Longfellow. Meets expectations. So most agencies have meets expectations, and then there'll be like a top line, outstanding, excellent. These are ratings at the end of the year that everybody gets, whether that's the end of the fiscal year or end of the actual calendar year. Meets expectations is usually the lowest of the acceptable categories. Anything below that, usually it's a 3.0, and then below that, you get essentially a 0, right? You get a performance improvement plan. You get told that you may get terminated if you don't improve your performance. Meets expectations is bare minimum. So that's what this is communicating to me. The mid-year rating was outstanding. So he got a great mid-year rating. And that apparently is not good. I mean, that wasn't good enough to carry him forward, but he hasn't changed. His performance hasn't changed over the rest of the year. So what I'm seeing here is that he has reported what he believes to be discrimination, and what I think is quite arguably discrimination in the form of a hostile work environment based on national origin or race. He's reported that to Dr. Davis. And then Dr. Davis came back, and it seems like she has changed his rating, but disconnected from his performance. And I would like to know, why did that happen? As an attorney, that's the thing that concerns me most when somebody comes to me with a statement like this is, why did this person change their reaction to you, right? And the only thing that I have in this fact pattern is that Dr. Davis was aware that Dr. Longfellow was making allegations of discrimination against Dr. Menschenleid. So why is Dr. Davis changing this performance evaluation in March 31st? And then not receiving a bonus? Okay. Both of these sound like they're retaliatory effects from the report back in back in 2020 that Dr. Longfellow made about his coworker, Dr. Menschenleid, right? And this is not uncommon, that an employee will make a complaint about a coworker to a supervisor, and the supervisor, instead of saying the wrongdoer, the person who is creating the hostile work environment, is the person who should get punished, they're saying the person who is complaining to me needs to get punished because I don't want to deal with this. Certainly in a situation where Dr. Menschenleid was a well-respected doctor, had lots of friends, there would be no reason other than compliance with the law for Dr. Davis to take action against him. She may even not want to take action against him. She may want to promote him. She may want to keep him in the fold, so to speak. And if Dr. Longfellow, if he's not well liked by management, it can be an easy choice for a manager to say, you know what, I don't want you to file any complaints about, in this case, Dr. Menschenleid. I don't want you to put his job in jeopardy because I need him here. I want him here, right? And even though, the appropriate response from the agency would be to investigate this, and if it turns out to be true, to then take corrective action based on that. And that may be what she's afraid of. I don't want to take corrective action against somebody who's creating a hostile work environment. This is a common problem, especially with sexual harassment perpetrators, people who are, very valuable employees, or even, like let's look at some of the people who own companies, the Weinstein Group. You're talking about people who have a lot of power, and people who speak up are speaking truth to power, and that's a scary situation for a lot of people. And that is unfortunately where a lot of this retaliation comes in, and I think it's scary. And I wouldn't blame anybody for feeling like, well, geez, why am I going to do this if I'm just going to get my head chopped off? Anyways, in this particular factual scenario, Dr. Davis, it looks like, could be retaliating against Dr. Longfellow for having complained about Dr. Menschenlein. And I think that's pretty apparent down here. And so what I would note here is that now we have a new basis. We have retaliation. And that retaliation applies to the performance evaluation and also to the bonus. Both of these are independent bases for adverse actions. So retaliation could be one of them, could be the other, could be both. I would definitely include, if I'm drafting this for Dr. Longfellow, I would definitely include both of those as separate actions and say, why do I think this is retaliation? Well, he complained in 2020 and now, he's not getting the bonus that he otherwise probably would have been getting. I'll show you a little bit more about that in a bit. Okay. So one last thing, as I'm reading through this, one last thing that could be in here is Dr. Menschenlein could be coming down here and impacting these two events. So if there's a performance evaluation of bonus, if what Dr. Menschenlein is talking about not liking Fijians, and that is impacting the performance evaluation and the bonus, arguably he is causing his discriminatory animus is causing Dr. Longfellow to have a lower performance evaluation and to be missing a bonus. So both of those things, I would say here, race and national origin, these count down here as well. I would put that in the formal complaint because it certainly could be one of the reasons. It's not out of the question on this fact pattern. There's nothing directly suggesting that he's doing this, but a lot of employees, they don't know what's going into their performance evaluation. They don't know whom their supervisors are talking to. It's a difficult position to be in. And one of the pieces of this is you don't have to actually know each piece of what's going on behind the scenes to be able to make an allegation of discrimination. And that's what I would see here. That's what I would include in addition to what's facially on this page. Okay. So I'm going to talk now about going through this complaint of employment discrimination. This is the form that the VA puts out. So I'm just going to scroll through this real quick just to show you all what's here. It's 2 pages long. The second page is just instructions. These instructions are dense, difficult to understand, and for the most part probably irrelevant. If you look here, they give you some instructions here. Should be filed with the ORM district office that is identified in the notice of right to file a complaint. So it's not actually in this document. You need to figure out what that is based on the letter that the EEO office issues to you. And then they talk here in general about, what counts, what doesn't count. Honestly, if you are filling out this form by yourself and you have questions, I would contact an attorney. I would try to figure out how can I get to somebody who's an expert in this area, because I have seen instructions like this they're too generalized. They're intended to be for anybody. And you want instructions, you want help with these that's going to help you, not just help everybody in general. So let's walk through the rest of this now. That's my spiel about discrimination complaint instructions. I think that they aren't that helpful. And if you have serious questions about them, you should seek out professional counsel, because sometimes you have real questions and they need to have real answers, and some form just is not going to have the answer that you need. Okay, so the first thing is these top ones. These are all obvious here. Email address. Do note that when you put your email address on here, put an email address on here that you're going to check, because if you miss an email because of what's in this, because you sent it to a secondary email address, something you don't check ever, you may miss something that's really important. So consider putting in, your main home email address. One thing that I've seen from people is that they'll put their work email address in here, and then they'll leave work to go on vacation. And let's say they go on vacation for a couple of weeks, they come back, they could find out that, they've received correspondence about their formal complaint, they've missed it, and timelines have run out. I think you can easily avoid that by just checking your email and putting in there an email that you're going to check frequently. Okay, so the rest of these are pretty self-explanatory. The next part of this is this, 8, 9, and 10. So this is the section that I'm going to talk about right now. The basis. What is the basis? I want to go back to what we had here from Dr. Longfellow. The bases are national origin, race, and retaliation. Okay, those are the bases that Dr. Longfellow is bringing this claim under. Okay, and what are the actions? The actions are the hostile work environment, the performance evaluation, and the bonus. So when I look at this, it asks you for a basis, and then it seems to suggest that you should fill out the basis here, and then describe the claim here, and then put a date over here. Now, it doesn't say that's exactly how you should do it, but that's how I read this as asking you to do it. Now, note, for formal complaints, EEOC regulations control what is a formal complaint and what isn't, what is enough information and what isn't. They don't say that the EEOC's regulations, at least as of right now, don't say that you need to use a particular form or any form. And in fact, you could write it on the back of a cocktail napkin as long as it met all of the other requirements. There are famous cases in contracting case law where that's exactly what people have done. Now, I'm not suggesting that you do that, but I'm saying that if somebody feels himself getting really stuck with this, it may just be better to ignore the form. It may just be better to walk away from it and say, I'm going to fill out what I can, and then I'm going to say, for example, see attached letter. I apologize for the terrible handwriting. That's why I type everything out. So that's one of the reasons why I don't like this form, is because it kind of chops these things up into unnecessarily narrow ways. I mean, this is how somebody like I would. I mean, I would want to do this, but I'd want to do this on my own. I would want to look at the claims and pull out these little pieces of it. I don't think that most people are in a good position to be able to do this and do it completely. Find all of the bases, find all of the claims, and connect them all. Because as I was noting before, there are many ways that things can be connected that you just don't know about. So you could have a race claim, and you could have 1, 2, 3 actions, but it applies to all 3 here. Okay? And then you could have retaliation down here. And that applies to 1 and 2, but not 3. Well, see how you can already see how this is trying to slice and dice things up in a way that just, it's not helpful. It's helpful for people to be thinking about this process, but in most cases, it's easier for somebody to just write out a narrative and say, this is what happened. This is what I think it is. And that's in fact what I'm going to show you here in a couple of minutes. Just writing a simple letter can be much more helpful. Okay. So I'm going to go over some other things here. Remedies sought. Remedy is like, do you want damages? What kind of damages do you want? Most people have no idea what kind of damages are even available. And that's a big analysis, and there's certainly nothing in what we saw that would be enough to make a complete damages remedy. right? You're talking about emotional damages. You're talking about back pay. You're talking about potential consequential damages. You're talking about attorney's fees. If I'm writing one of these, normally I would just tell the agency, I would say, tell the agency, I would like all legal remedies to which I am entitled, because then that covers everything, at least all the remedies that you're entitled to. There are some other remedies that are not entitlements. That's okay. You don't need to be entitled to absolutely everything. Some things like, for example, if you have I'm just trying to think off the top of my head here. One of the remedies that they can do is a posting order. It's an order for the agency to post in the workplace that discrimination has occurred and that they're going to try to remedy it in the future. You can find these online in the EEOC's case law. That's less of an entitlement to the employee. It's more of just a way of remedying the situation. But the remedies sought, there's nothing in the EEOC regulations that require you to identify your remedies sought, and I've seen no reason to believe that remedies, if you put something in here, I have no reason to believe that you'll be limited by that in the future. So I wouldn't worry too much about the remedies sought. Do you have a representative? This is where you would fill in your attorney representation information. You can have a non-attorney representative, but they can't sign a formal complaint. That's the rule. So it's always fine if an employee signs his or her own formal complaint. If they have an attorney, the attorney can also sign, but like a union representative typically can't sign. Telephone number, email address. So this is all pretty obvious stuff. Have you contacted an EEO counselor? Yes or no? This is the discussion of when did you contact first an EEO counselor? When did, in this case, Dr. Longfellow contact an EEO counselor? It was on the 31st. When did the events happen? Well, for the hostile work environment, the most recent event was March 31st. So that's within the 45 days before he contacted an EEO counselor. And then the two other events, the loss of a bonus and the performance evaluation, were both during the 45 days prior to that. So both of those are timely. And so he could just fill in name of the EEO counselor and then put in 3/31/21 right there. Okay, so the next parts of this are about grievances and some other minor matters I mentioned before, the Merit Systems Protection Board. This one is, have you filed a grievance on any claims? These are about what's called an election of remedies. An election of remedies means that you're going down one road and you can't switch over to another. So if you're going down the grievance road, you can't switch and say, well, now I want an EEO complaint. I want investigation. I want an administrative judge. Once you've filed a grievance, a written grievance, that's going to be the election of remedies here. Now, what constitutes an election of that remedy? If the CBA covers it, doesn't cover it, that's something you should talk to a lawyer about. Same thing with the Merit Systems Protection Board. Certain claims go through the Merit Systems Protection Board, some don't. They're just looking for the information. Did you file with the MSPB about a particular claim? Because if you did, that may be an election of remedies, and they'll say we don't need to investigate this because you've got a pending case in front of the MSPB. If you think that this might be an issue, do talk to an attorney, because you want to sort that out before you spend a lot of time trying to pursue a case that may not ultimately benefit you. And that's not to say that your case gets totally thrown out. It just gets pursued down one of the avenues, but not the other. Okay. I don't know where else you would file such a complaint, but they ask for that information. And then down here, signature of the complainant. So if I'm the attorney, I'm going to sign this right here. Okay, and then date it. So that's the VA form. What I really don't like about the VA form is down here in this area here, I think it's confusing. I think it's unnecessary. And I'm going to show you right now what I would do instead of trying to fill this out and figure out all of these things. And that is, I'm going to switch over here to my laptop. All right, so now I'm going to show you what I would do on in drafting a letter. I'm not going to draft the whole letter, but I'm going to show you kind of how I would structure it and why I think it would be a good idea. So here I've already filled out some basic information. I filled out, my information up here. Dr. Longfellow versus the VA, that's the federal agency here, and I identify it as a formal complaint. And then I add in here, I would do this for Dr. Longfellow. To whom it may concern, please accept this letter. I just want to make sure that they understand that I am trying to include this as being part of the formal complaint. It's not just a cover letter. Hostile work environment. So the way I like to do it is I put in here hostile work environment. That's one of the claims. Negative performance review. That's another claim. And failure to provide a bonus, as we talked about, that's another one of Dr. Longfellow's claims. And then what I would do is just describe the event. So on March 31, 2021, okay, so the way I styled this is on March 31, 2021, and prior, I was subjected to a hostile work environment when Dr. Menschenleid made numerous negative references to Fijians. And then I put in the parentheses, race and national origin. Okay, and so what I would do if I were drafting this out is I would include a little bit about Dr. Longfellow up here, including his race and national origin, even though that's going to be something, well, actually it's not. It wasn't specifically identified in the information on that VA form, so it's important to identify it somewhere. So I would just identify it up here, race, Asian / Pacific Islander, and talk about the national origin. He is from Fiji, so that is his national origin. And then I would describe the events here that Dr. Longfellow went through. I'm not going to go through that. Frankly, what he had described before was probably sufficient. I would just ask him some more questions about, what were the other events that happened, specific comments that he made. There were some general descriptions. I'd like to have quotes in here that I think would be helpful in understanding exactly why this was about a national origin. What I would definitely not do in a situation like this is just leave it unadorned like that. Including details helps somebody else understand why the claim is being made. And it may not be strictly necessary, but if there's ever any question, it's already there in the formal complaint. Plus, people's memories tend to fade over time. You may remember what happened last week, but can you remember what you had for breakfast on Tuesday 3 years ago? Probably not, unless something truly extraordinary happened on that day, and maybe you can remember that. But this is the start of how I would start structuring a letter to attach to the formal complaint, right? And then I would fill this in with the details below. But by doing it this way, you're ensuring that you are explaining why you believe that something is a particular claim, and you're connecting it with the bases. And that it's unmistakable when you say the race and national origin, and you identify what those are. It makes it easier to read for somebody who's reading this later on the EEO end to say, okay, this is what this person is saying, and this is what the race is. This is what the national origin is that he's connecting with this particular action. Negative performance review, I would do the same thing. I would just type out, I believe that on March 31st, 2021, I was discriminatorily denied a positive performance review because of my race, national origin, and because I engaged in protected activity. So I'll just put that last bit in here. I'm going to copy and paste this. Put in protected activity. You could just call it retaliation. But by including that, it's quite obvious then that this person is claiming that they've been retaliated against. Okay, and if you wanted, if Dr. Longfellow wanted, it might even be a good idea here. Prior EEO activity. I didn't see when it was in 2020, but 2020 discrimination complaint. If you were wondering what constitutes protected activity and what doesn't. It's actually a very complex analysis. I would definitely give an attorney a call. So that is generally how I would do it. Obviously, I would write out the rest of this, but I think that's a good start and is a good beginning to how an employee can think about taking their case, taking their claims of discrimination, and extracting from that the information that they need to be able to put into a formal complaint. Now, this was just an example of something that I totally made up, but this is the kind of thing that a lawyer can do for really anybody. If you have a question about your particular formal complaint, I would definitely get in contact with an attorney. Many attorneys will take a look at your formal complaint and just talk with you about the facts. Let me make a pitch for myself here. When I do this, I sit down with a client and I talk about not just what is, literally on the page. I talk about what's going on in the background, because a lot of times people are so focused on, for example, a hostile work environment that they miss the retaliation, or they see that somebody has retaliated against them and they miss out that somebody behind the scenes might be interfering with in this case, a performance evaluation for discriminatory reasons. And then so a formal complaint, you have to walk that back later. To understand why formal complaints are so important, you have to understand what's going to come from this. If you haven't been down this road before, it's not entirely obvious. So when the formal complaint gets filed, if the claim is accepted, meaning if it doesn't get dismissed, the formal complaint will then generate an investigation. The agency is responsible for conducting an investigation. A lot of times they hire contract investigators to come in from the outside and to investigate the particular allegations that are made in the formal complaint. Notice that if it's not in the formal complaint, it may not, most likely won't, get investigated. So it's important, if you have claims that you need to have investigated, you want to make sure that those claims are laid out correctly in your formal complaint so that you get the investigation that you need to be able to prove those, because that may be your only opportunity to get some of the background information. I talked about Dr. Menschenleid possibly being involved in messing around with the performance evaluation and the bonus for our hypothetical Dr. Longfellow. Dr. Longfellow would have no way of knowing that. He would have no way of knowing whether Dr. Menschenleid was involved in that. But an investigator has the power to go in and talk to Dr. Menschenleid and talk to some of the other people who are involved in the performance evaluation process and get more details about that. Possibly he was, possibly he wasn't. By the time you get through the investigation, they will give you what's called a report of investigation, and that investigation will have affidavits or other types of documentary evidence about the specific claims. So that should be one of the things that would be in there if it's put in the formal complaint and explained in such a manner that the investigator will understand the connection between those two. Now, this is where having an attorney can also be helpful, because this is what's known as cat's paw theory. Okay, the fact that there's a theory out there kind of tells you already that the investigator, who's most likely not an attorney, they may not fully comprehend that, or they may just not, it may not be obvious from the facts. You want to be able to point that stuff out to them at the time that you're making your formal complaint, or at least when you get to the beginning of the investigation, so that they know, they can go in, they can see, okay, this is what this person is alleging happened. Let's see if that actually happened, and start asking questions about it, asking for documents and things like that. Once you get through the formal complaint process and you've got your report of investigation, then you can request a hearing in front of an administrative judge. That administrative judge process is way beyond the scope of what we can talk about here. But typically it takes a lot more work to be able to get the same amount of information that you could get in a report of investigation. Not only that, the report of investigation is already in the record by the time you get to an administrative judge hearing. That is the record, right? And then you can supplement that record, but that's already in the record. Whatever documents are in there are in the record. It's important to note that discovery, if you hire an attorney to do discovery, it could be very, very expensive. And so that's why it's important to get it done right the first time, so that you don't have to go back and do much more than is necessary to supplement that record. Now, in an investigation, you're not going to get everything. When investigators send document requests out, they don't say, give me all of the documents in this particular category or about this particular decision. They just let the supervisors put in whatever documents or information they want. They can leave things out. And so that creates gaps. Sometimes those gaps are really important to fill because somebody might say, I took this action based on X, Y, and Z, and fails to mention, and also because he was Fijian. So that's where it can be really important to have an attorney help you out through the process to understand where those gaps are, how you can fill those gaps in discovery, and how you can get, use the report of investigation that you have, which hopefully is good, to be able to extend that and to get the information that you need to actually prove your claims. It's rare that claims are provable based on what is in the report of investigation alone. And certainly, from a lawyer's standpoint, from a litigation standpoint, it's much more risky to rely solely on the information that is in that's in the report of investigation based on the formal complaint. You want to extend beyond there if there's a major question that needs to be answered. So that is how I would do a formal complaint. I think that formal complaints are within the ability of all employees to do, but I think it helps to have a lawyer. I think it helps to have somebody take a look at it. I think it helps to have somebody that you can talk to. And when you talk to a lawyer about your claims of discrimination, that's protected by the attorney-client privilege, so you don't have to worry about somebody finding out information during the course of that meeting that might be harmful to your case. My name is Kyle Ingram. Thank you for watching this whole thing. I know it's been lengthy. I really do enjoy doing this work, so this has actually been fun for me, and I hope it's been informative for you. Again, none of this is legal advice specifically for you. This is just showing you how I would do a formal complaint and kind of the general gist of the things that you can do in a formal complaint. If you're looking for somebody to take a look at the facts of your case and help you write a formal complaint, look at my website, contact me. I may be able to help you out with that. If not, there are plenty of attorneys out there who can. Please do find somebody who can help you, who is familiar with this area, because it's too important not to get it done right. Thank you and take care.